opened the session at exactly 2 p.m. on July 20, 2026, with 21 senators present, constituting a quorum. For administrative matters, the Impeachment Court was in receipt of the House Prosecution Panel's motion to set conference for the transfer of markings and comparison of video exhibits last Friday, July 17, 2026 at end of day, requesting the same to be scheduled today, July 20 at 9 a.m. The presiding officer granted the motion only to the extent necessary to allow the proper transfer of markings, comparison, and verification of documentary and video exhibits that had already been identified during pre-trial. He emphasized that the conference is purely administrative and evidentiary preparatory and cannot be used to introduce new evidence, substitute different exhibits, cure evidentiary deficiencies, or prejudice the respondent's right to inspect the evidence and raise objections. The conference was, however, set for July 21, 2026 at 9 a.m. instead of today before the clerk of the Impeachment Court with both parties' counsel present. The order likewise expressly reminded the prosecution that the court will not countenance trial by ambush and that any material deviation from the pretrial disclosures may result in the exclusion of evidence or the issuance of other protective orders necessary to safeguard fairness and due process. The respondent was also given the same right to transfer markings on July 21, 2026. The presiding officer likewise ensured the prompt implementation of the court's compulsory orders. The Office of the Sergeant-at-Arms formally reported that the subpoenas and subpoena duces tecum issued by the court had been successfully served upon the identified witnesses and custodian of records, including officials of the House of Representatives and Landbank of the Philippines, with corresponding proof of service submitted to the court. This confirms that the court's directives are being promptly enforced in preparation for the presentation of evidence during the impeachment trial. The presiding officer and the Senate President also confirmed receipt of a letter from Senator Mleta, which the presiding officer deferred ruling and merely referred the matter to be taken up the Senate as a legislative body. For preliminaries, Senator Judge Erwin Tulfo objected emphatically about the use of the time of the impeachment court by the senator judges in manifesting their own personal concerns not relating to the merits of the case before the court, which according to him is an injustice to Respondent Duterte. After the manifestations and rebuttals of Senator Judge Alan Cayetano, Senator Judge Robin Padilla, Senator Judge Vicente Soto moved that the matter be referred by the impeachment court to the Senate as a legislative body, seconded by Senator Judge Kiko Pangilinan. The presiding officer ruled that the manifestation of Senator Judge Robin Padilla shall remain on the records but referred to the Senate as a legislative body, and apologize to the parties and councils why these matters are being allowed because there is no other venue or forum to ventilate since the Senate as a legislative body is still in recess. He is hopeful that once the session resumes in a week, all these matters will be ventilated in that forum and not before the impeachment court. Senate President Sherwin Gatchalian reiterated that the matters will be surely discussed before the Senate as a legislative body and thanked his colleagues for both the understanding and their active participation. After the clarification of the Senator Judge Joel Villanueva, the presiding officer confirmed his ruling that the vote will not be per issue but per motion, as the motions are indivisible and should be taken as whole, citing as precedent what happened in the Corona impeachment trial. As to the oral arguments, the House Prosecution Panel was represented by Chel Diokno and the respondent was represented by Attorney Michael Poa. Senator Judge Joel Villanueva asked the House Prosecution Panel whether the request for subpoena already goes into the admissibility of the evidence. He also asked the defense whether such issuance would already prejudice the respondent's rights relating to the inadmissibility or admissibility of the records or documents. Senator Judge Pia Cayetano and Alan Cayetano also asked questions regarding the effect of illegally acquired evidence, about the due process requirements of any compulsory process, about the decision of the Supreme Court in Duterte versus House of Representatives in relation to documents before the respondent's term as an impeachable officer. The presiding officer asked the defense when the respondent and her husband got married, to which Attorney Powa admitted 2007. He further inquired the existence of any prenuptial agreement, to which Attorney Powa also admitted that there was none and that the absolute community property regime applies. As to the resolution of the court, it was surgical, not sweeping. Today, the Senate, sitting as an impeachment court, issued a calibrated, meticulous, and legally unassailable resolution regarding the prosecution's request for subpoenas directed at the BIR, the AMLC, and various banking institutions. The guiding principle of the impeachment court today was simple. The search for truth will be unyielding, but it will not be an unbridled fishing expedition. The court's actions are surgical, not sweeping. Here are the 6 critical takeaways from today's rulings. First, on the spousal accounts, the court granted the subpoena for the peso accounts and tax records of the respondent vice president, her husband, Attorney Manasa Scarpio, and 20 specific corporate entities. To those asking why a private citizen's accounts are included, Philippine civil law is clear. Under the family code, the couple is governed by the absolute community of property. There is only one marital pot. It is a legal and mathematical impossibility to audit the wealth of the vice president without auditing the community property she jointly shares with her husband. Also, Section 8 of Republic Act No. 6713 requires public officials to disclose their assets, including those of their spouses. Their financial interests are therefore intertwined for purposes of disclosure. Second, the exclusion of dollar accounts. The court strictly denied the subpoena for any foreign currency deposits. The court is bound by the rule of law. Republic Act 6426 provides absolute secrecy for dollar accounts unless there is a written waiver from the depositor. The court learned from the Supreme Court's temporary restraining order against the Senate during the 2012 Corona impeachment in the case of PS Bank versus Senate Impeachment Court. The court will not overstep these statutory boundaries again. Third, the 2007 to 2021 timeframe. The court approved the request for historical records dating back to 2007. These are not being admitted to charge the vice president with new past offenses. They are strictly allowed as a factual baseline based on the cases of Office of the Ombudsman versus Bernardo and Concerned Taxpayer versus Doblada Jr. To determine if wealth accumulated today is disproportionate, there must first be an establishment of what the spouses legitimately owned yesterday. Fourth, on the corporate entities. The court proved its refusal to allow fishing expedition by outright denying the subpoenas for JTC Group of Companies, Philippines, Inc., and Pikimong Philippines Corporation, as the documents submitted to the court neither show the names of the respondent and or her husband in the general information sheets of the two corporations, nor the admitted salience by the respondent disclose these two corporations. Absent concrete prima facie proof tying these two corporations to the respondent, the corporate veil of fiction remains. The impeachment court only granted subpoenas for the 20 entities where the respondent's links were prima facie proven by documents submitted to the court and or admitted by parties. As to the Carpio Lawyers Partnership, the court acknowledged that the issuance is subject to whatever legal remedies they may resort to in order to raise any attorney-client privilege over particular documents at the proper time. Fifth, on the BIR records, the court granted the subpoena to the BIR as to the respondent, her husband, and 20 entities, which is composed of 19 corporations and 1 partnership. Based on the case of DPAD versus Spouses Olivan, that states Section 270 of the Tax Code obviously does not address the confidentiality of ITRs. The tax code recognized disclosures permitted under its specific provisions, other statutes, or in any other manner provided by law. The constitutional authority of the Senate Impeachment Court under its rules to compel the production of relevant evidence constitutes such lawful process. But the court recognizes that under the tax code, the commissioner may still invoke the requirement of the president's authorization to release these documents. The court has done its constitutional duty. It will now await the official return of the BIR commissioner on July 30, 2026 at 9 a.m., cognizant of the fact that the issuance of the subpoena is not necessarily the final act with respect to the requested documents. Finally, on the Anti-Money Laundering Council, the court granted a subpoena covering the respondent, her husband, and 19 listed corporate entities and one partnership, guided by the doctrine in the Supreme Court case of Republic versus Sandigan Bayan that the confidentiality wall under Section 9C of the AMLA protects covered banking institutions from liability when reporting to the AMLC and does not paralyze it from answering a lawful subpoena issued by the Impeachment Court. However, to protect state secrets and intelligence methodologies guided by the Supreme Court doctrine in Almonte versus Vasquez, the presiding officer ordered that AMLC records be submitted first in camera for his review first before turning them over to the parties to determine if any AMLC methodologies would unnecessarily be disclosed that is not proportionate to the requirement of the subpoena. The impeachment court remains an impartial tribunal. The court will compel the evidence the law allows and it will protect the rights the law guarantees. The impeachment court provides the following summary of the presiding officer's resolutions pertaining to the issuance of subpoenas to the BIR, AMLC, and the banks, which you will see in your printed media briefer. I made a table or matrix for easier referencing. As to manifestations and motions, upon Senator Judge Alan Cayetano's motion, the presiding officer granted the filing of written dissents to the presiding officer's ruling and the other senators who will also file their written dissents for the record. Upon the query of the presiding officer, the lead House prosecutor confirmed that they will be presenting Ms. Marivic Pareja and two Landbank officials, namely Violeta Constantino and Ninita Camposano, on July 21 and 22, 2026. Following rulings by the presiding officer, the trial was adjourned. Pursuant to the rules of procedure on impeachment trials, the impeachment court will resume session tomorrow, Tuesday, July 21, 2026 at 2 p.m. The agenda is a continuation of the presentation of the House Prosecution Panel's evidence-in-chief for Article 4 with NBI Director Attorney Melvin Matibag as witness. Any questions?
Questions? Hello. Attorney, bakit hindi na umabot sa punto na magbotohan ang mga senator judges dun sa ruling sa dalawang motion ng prosecution?
Isa lang sagot ko. Rule 6 of the Senate Impeachment Rules allowed the presiding officer a wide latitude of discretion to be the one to resolve any matter or motion based on evidence. And only, as I explained before, only if the presiding officer decides on his own to throw the question back to the court, to the impeachment court, that voting will happen. Now, another voting can happen if there was a senator judge who will appeal the resolution of the presiding officer, but that did not happen. So there was no voting for today.
Another, last on my part. Yung decision na binasa ni presiding officer Chis Escudero, was it done today or over the weekend? Kasi kung over the weekend, bakit nagkaroon pa ng pagtatanong yung mga senator judges dun sa defense and prosecution? Gayong may written decision na siya, hindi ba waste of time yun?
As I said, during the July 6 first day of impeachment, because this request of the prosecution has been already stated in their pre-trial briefs. The presiding officer, as a matter of course, was already ready to rule on the subpoenas. However, upon manifestation of House Prosecution Panel, Congressman Diokno, that they have filed a renewed request for subpoena, that the resolution of the presiding officer was deferred, and it was only after the request of the defense to be given a copy of such, and the senator judges asking that oral arguments be done, that the presiding officer yielded to such oral arguments that have been scheduled last Monday. So basically the main chunk of the decision of the presiding officer has already been prepared even before July 6. So I think the presiding officer also during the caucus consulted his fellow senator judges about it and asked about their views regarding the matter, and that is the request of the other senator judges to study it for until the weekend and until today. So, handa naman siya ever since.
Attorney, so yung Anti-Money Laundering Council and yung mga banks are mandated, obligado sila, tama po ba, na mag-comply. Pero as to the BIR, subject to the authorization by the President, tama po ba?
Obligado rin po siya mag-comply. However, she has a recourse in law which is under, he has a recourse in law which is under Section 71. So as I was explaining, this was the same course of action that happened during the Corona impeachment trial. The subpoena was issued to Commissioner Henares at the time, and then Commissioner Henares, she asked the permission of the president at the time to be able to comply without violating the subpoena, and to also not to put her in jeopardy of criminal case. She asked the permission. So as the presiding officer has said, it is cognizant that this is the first step that might trigger such permission to be had. And he also explained it in his resolution that without such permission, no evidence from the BIR will be allowed to be taken by the Impeachment Court.
Pardon the ignorance po, Attorney. So, ibig sabihin, yung BIR Commissioner ang gagawa ng pamamaraan para makomply ang subpoena ng Impeachment Court.
He now has this subpoena to show the president, for the president to now respect a co-equal branch of the government, for him to issue the permission to the BIR commissioner.
Sir, just on the technical side, can the BIR commissioner, I'm sure he is watching now, pwede na po ba niyang i-trigger already? Can he already ask the president for permission, or dapat po ba mag-a-appear muna siya sa court at saka pa lang po maisesend yung request sa Malacanang?
The schedule for him to comply rather. Nakakalimutan kong hindi na si Commissioner Henares. For him to comply with the July 30, he should already secure the permission before July 30, because the deadline for his compliance is July 30.
So, ibig sabihin, anong date po yung mismong issuance ng subpoena ng court if ang compliance is July 30?
Today i-issue yung subpoena, tomorrow siguro masasend.
Question lang po regarding dun sa after the subpoena, does it mean na pwede na siyang buksan, or para bang meron pang another deliberation on that?
Wala na po.
So meaning pwede na siyang i-deliberate and use as an
Wala na
evidence?
pong bubuksan kasi wala namang box tayong tinutukoy. Ang hinihingi po ng korte diretso ay dokumento na isasubmit ng BIR commissioner sa korte. So whether that's in a box or in a folder or in a clear folder or in a Manila folder, it's his discretion to submit to the court.
For the deadline naman po ng other institutions like banks, aside dun sa BIR, meron ba silang deadline?
Lahat po July 30
July
at
30
9 a.m. pati po yung Anti-Money Laundering Council. Kaya lang po bago makita ng both parties yung mga dokumento na galing sa Anti-Money Laundering Council, titignan muna ng presiding officer kasi based on Almonte versus Vasquez, titignan niya kung doon ba sa mga reports ng Anti-Money Laundering Council, meron bang unnecessary disclosure ng methodology ng pag-iimbestiga ng Anti-Money Laundering Council pag ibinigay yung papel na yon, yung reports na yon. So, kailangan lamang iklaro ng presiding officer in camera before the clerk of court, i-confirm niya lang doon sa representative ng Anti-Money Laundering Council kung meron ba o wala. Kung wala namang madidisclose na methodologies, then the parties will have unbridled access to those documents and upon presentation to the impeachment court, makikita rin natin yung mga dokumento na yun.
Attorney, question, clarify ko lang po. Meaning po ba yung binasa kanina ni Senator Cheese, it was a ruling purely by him as presiding officer, or do we take it na since walang nag-contend from senator judges, nakuha yung support ng ibang senator judges?
The ruling of the presiding officer is the ruling of the impeachment court under Rule 6 of the Senate impeachment rules. So wala pong pinag-uusapan na ruling ng presiding officer, tas ruling nung mayorya, wala pong ganon. Ruling po yon ng impeachment court.
Wala pong bilang nung simple majority na
Wala po.
inaabangan.
Wala
Pero-
po. Because under the rules, he is allowed to do such ruling. Under Rule 6.
Wala rin pong napag-usapan kaya na, kasi supposedly kung may point of contention from senator judges, meron at merong magsasalita. Pero nagkaroon po ba na pag-uusap nun during the caucus o conditions or compromise na lang?
I'm not privy to that. But of course, since no majority senator judge raised any issue on that and no minority senator judge appealed the resolution of the presiding officer as held by previous impeachment courts in the Corona and the Estrada impeachment, the ruling of the chair will stand as unquestioned.
Thank you, Attorney.
Sir, no, just to paint the picture dito sa subpoena, no, is there a possibility na, or allowed ba na mag-decline si President Bongbong Marcos? And if so, if he declines, what happens?
Of course, that is within the realm of possibility, but President has already shown, in history has already shown that merong basihan naman yung ating presidente para i-issue yun. And as I said, it is not really an act against the vice president. I think that will be unfair to characterize the president's giving permission to the BIR commissioner for the disclosure to be seen as an act against the vice president. It is actually an act of respect to a co-equal branch of government. And since the impeachment court has officially acted on the request for subpoena, and the BIR commissioner has remedies in order for him not to be in trouble with the law under Section 270 and be cited in indirect contempt, then he can get the permission of the president, and the president already has the legal standing or the legal reason to issue such permission.
Attorney, last na lang po from me. Yung sa manifestations po ng senators not related to the impeachment trial proceedings, do we take it na pag sa mga susunod na araw, merong gustong mag-manifest na walang kinalaman sa impeachment, bawal na po ba?
I think the policy is they will hear it first. And then upon hearing the manifestation, the presiding officer or any senator judge can determine if that is relevant or irrelevant for the impeachment court to be taken up. And they have a body of arsenal and weapons to use in order to either expunge that from the records or keep it on the record or refer it to the Senate as a legislative body, which we have seen earlier that there was no expunction of the manifestation made by Senator Judge Robin Padilla. There was just a referral to the Senate as a legislative body.
Thank you po.
Okay na po? Ay.
Ano lang, administrative matters. Administrative matters lang, attorney. Attorney, napag-usapan na ba paano yung, anong oras yung trial simula next week?
Wala pa po. Pero siguro in the next few days, makakaroon tayo ng update regarding that. Kasi malapit na rin naman yung SONA next week na. So, I think the presiding officer will give his final resolution on that, yung sa scheduling. By Wednesday siguro, ang latest. Thank you po.